Good evening and welcome to this latest edition of The Elephant in the Room. And once again, I am really pleased to have my friend, Mr. Waikwa Wanyoike, with us today. Waikwa is the immediate former executive director of the Katiba Institute, which is the country's leading non-governmental organization involved in public interest litigation. He's now currently with Open Society Foundations in London. And Karibu Waikwa.
Asante sana, John.
Waikwa, you've been involved in the whole area of public interest litigation. You're one of our pioneers. Our Chief Justice, what I've been told is about, the advisory by our Chief Justice vis-a-vis the 2/3 gender rule is not just an advisory, but it is an instruction. The president has to implement it. But I just wanted to ask you is just a little bit about just a brief take by you on the journey that caught us here. How did we end up here with this kind of very, very consequential advisory or ruling by the Chief Justice with regard to the 2/3 gender rule? It seems to have caught people a bit flat-footed.
Yeah, so the historical journey on this actually goes way back to 2010, and in fact before that. When we promulgated the Constitution. But before we promulgated the Constitution, some of the issues that came up when we were discussing the Constitution was a need to make sure that our Constitution created a very inclusive state.
Yeah.
And so when you go to, for example, Article 10 on values and principles, you see principles of inclusion, including on marginalized and sort of historically discriminated groups. And also our Constitution is very strong on Bill of Rights, including on non-discrimination.
Yes.
So in 2010, when we promulgated the Constitution, two things happened. One, we had a Constitution that took effect immediately, but it was known that there are certain things that needed to be elaborated in legislation. So the Constitution contains what we call the 5th schedule, which provides a schedule of the laws that were to be passed to fully implement the Constitution. Part of those laws were laws on inclusion, and especially when it comes to issues of gender representation. Specifically, when you go to Article 81B, you find that that article says that representation in Parliament has to meet the principle of not more than 2/3 for any one gender.
Yeah.
And then that is also related to Article 27 on non-discrimination, but more specifically in Article 27, there is a specific requirement that legislation has to be put in place. Legislation and other measures have to be put in place to ensure that the principle of 2/3 is met, both in elective and appointive. The timeline that Parliament was given to pass the 2/3 gender law was 5 years, according to the 5th schedule. There was obviously the question about when the actual inclusion, the representation of 2/3 should have taken place. And so way back as 2012, that issue came up when Parliament was considering, or the Attorney General was considering ways to implement the 2/3, and he was of the view that it's going to be a difficult legislation to develop. So he went to the Supreme Court to ask the question, when does the principle in Parliament kick in, and when is that legislation supposed to take place? And he was told that that had to happen by August 2015 because it was a 5-year law, even though at the time the Chief Justice, Dr. Willie Mutunga, then actually said, no, the principle should take effect immediately. So after that, what happens is that 2015 comes and Parliament has not passed the legislation, because at some point Parliament really took the position that it was a very difficult legislation to pass, mostly because of patriarchy, because every formula that was being proposed that was a statutory formula, members of Parliament would fight it because they thought it required for men to yield certain positions. So in 2015, Center for Rights Education Awareness and Crown Trust went to court to ask the court what happens now that the law had not been passed. The court gave Parliament time to go, the Attorney General at the time, to consider the law and bring the law to Parliament so that it could be passed. And this is in accordance with Article 261 because there is a formula. And then that didn't happen because what Parliament had proposed was constitutional amendment, which, as we know, the various efforts they put in place were defeated. And so come 2016 and we don't have the law, the same groups go to court. And in 2017, they got an order requiring Parliament to pass the law within 60 days, failing which then anybody could advise the Chief Justice that Parliament was non-compliant, and the Chief Justice is required to advise the President to dissolve Parliament. And so we can discuss about what advice means in that context. But that's the journey.
Okay. What are the implications? I mean, as I said, the Chief Justice says, it's being called an advisory, but I've been told that advisory is actually not the correct word. The President doesn't actually have much of a choice here. What the Chief Justice has quote unquote advised is something that he must implement. So,
yes,
what are the next steps if you must do it? In a perfect world, what should Uhuru Kenyatta be doing as we are speaking now? I know people have gone to court, and the High Court has ruled, and there's a stay that sort of gives Parliament some breathing room. But in the perfect world, what should be happening after this essentially a ruling instruction from the Chief Justice to the head of state?
Yes. So before we go into the implications, let's talk about whether it's an advisory, whether it's an instruction. Of course, there has been a lot of debate, including among very senior lawyers, that what the Chief Justice has asked the President to do, it's up to the President to decide whether to do or not. That's not the case. This is not an advice that the President has to consider. In fact, all the Chief Justice did is to tell the President, Parliament was required to pass the law. It hasn't. You are required to dissolve Parliament. Yeah. Part of the reason why this debate is there is just because, including by some of the lawyers, is just that they have not done sufficient research. If you go to, for example, the Committee of Experts, which put that provision, it did provide an elaboration of what should happen. And it says that when the President gets, when Parliament fails to pass the law, the Chief Justice advises Parliament, and the President must dissolve Parliament. So going to the implication, the first implication is that Parliament is supposed to be dissolved by the President. Obviously, that's a very consequential implication.
Yes.
And the debate that we have now, other than the fact that there is a temporary stay from the High Court, the debate is whether the President will act on it. Yes. I'm not able to answer that, but yes, there is a constitutional obligation that he has to do that. The question then arises, how soon can he do it? So there is a debate about there is no timeline given to the President. That is not correct, even though the law and Article 261(8), which provides for the advisory to go to Parliament, to the President, does not specify the days, how many days, or the timeline that the President has, the Constitution has enough information about how long it should take. And the courts have already ruled what happens when the Constitution requires something to be done, but it's not expressly provided for in terms of timeline on when it should be done.
Yes.
The courts have said it's ordinarily or reasonably about 14 days.
Yes.
And 14 days is not just from the blues.
Yes.
If you go back to the Constitution actually anticipated that there are things that the President may be asked to do and he will not do. Yes. And so there are mechanisms that the Constitution put in place to address the recalcitrance from the President when he refuses to do certain things. And I'll give you two examples. The first one, which is the most consequential, was the coming into force of the 2010 Constitution. The Constitution, the transition provision, actually said if the President failed to promulgate the Constitution, the Constitution came into place automatically 14 days from the date the results of the referendum were certified.
Yes.
So 14 days is, you can see where 14 days is coming from. And transitioning from one constitution to another, if the Constitution itself thinks 14 days is reasonable time, you can't tell me a fairly mundane issue about sending MPs back so that we can have a by-election is something that cannot be done in 14 days. But the second way that the Constitution insulates itself, or another place where you can find the Constitution insulates itself from the failure by the President when he's required to do something, is in the passage of laws. If the President fails, for example, to assent to a law without giving reasons, that law automatically becomes law after a certain period. Okay. So even in this case, when you actually look at the Constitution, there is a very strong case that if the President does not act within 14 days, especially now after the court orders are lifted, because at least now there is a court order, then Parliament from that time is dissolved by operation of the Constitution. Then it goes to the second implication. What does that mean? Mm-hmm. Right?
Yes.
And the second consequential implication for me is, what authority does the current Parliament have as a Parliament? Okay. Or what authority will it have, especially once the orders of the High Court are lifted? And my position is that the Parliament itself will be unconstitutional and will have no authority. Okay. So that anything, even if it remains in place and people are not able to physically eject Parliament and cause an election, there will be serious constitutional concerns that anything that Parliament does not have authority of the law, including, and this is very critical, the one thing that obviously the President and Raila Odinga wants most to get from Parliament desperately, that is the passage of BBI, constitutional amendment, and hopefully eventually a referendum.
Yes.
This Parliament does not, as we stand, whether with the suspension by the High Court of the effectiveness of advisory or not, does not have the constitutional authority to amend the Constitution. Okay. And there is a good reason for that.
Yes.
The Constitution also says that when that things that are done outside the law are illegal, not from the moment that people find out that they are illegal, but from the moment they were done.
Done. Yes.
So there are a lot of concerns that if this Parliament, for whatever reason, or the President, for whatever reasons, completely disobeys the advisory, then what we are facing is a significant constitutional crisis beyond what we have now. And this is not a two-third gender crisis anymore.
No.
It's bigger and broader than
that. That's interesting. When does the crisis kick in? After how many days after Mr. Chief Justice Maraga's ruling? Where this what you're describing is quite troubling. That essentially this parliament at a certain point can no longer transact as a parliament.
Yes. Ordinarily, this should have kicked in to be reasonable. So it should have kicked in at most 14 days from the day that the advisory was delivered. For the reasons I've said, why we work with 14 days when we don't have a specified timeline in the Constitution.
Okay.
For now, there is obviously an argument that to the extent that there is a court order, then that is suspended.
Yes.
But if that court order for one reason or another gets lifted,
yes.
then again, it kicks in automatically from that day in terms of the illegality of parliament. But there is also another question that we are not engaging with at the moment, which we also need to engage. So parliament, and this is important, parliament is being sent home for failing to pass legislation on 2/3.
Yeah.
At this point, it's not even necessarily being sent home because it's unconstitutional.
No.
But as we stand, parliament is unconstitutional because any parliament that was to be formed after August 2015, yes. which was the effective date when the advisory by the Supreme Court took effect.
Yes.
Or being a bit more generous, August 2016, because Parliament managed to use a provision in the Constitution to extend that timeline by 1 year. Any Parliament that was formed post-August 2016 that is not 2/3 gender compliant is itself unconstitutional, because the Constitution anticipates Parliament to be constituted constitutionally when it doesn't have more than 2/3 of the same gender members. And that's a different question from the question about advisory and why parliament is being kicked out today. And we can engage with that.
I would like to engage it. What you're essentially saying, Waikwa, is that since August of 2016, Parliament, which has passed laws, committees that have issued reports, passed budgets, money that has been spent, etc., etc. You're saying that this has been illegal activity, unconstitutional activity.
They've been unconstitutional activity. They have been, because you are having transactions being undertaken by an illegal entity. What makes of an illegal entity? An illegal entity is an entity that is constituted outside the law.
Yes.
There is already very express provision of how Parliament should be constituted. Go to Article 97, Article 97 on National Assembly, Article 98 on Senate, then you read that with Article 81B on 2/3, and then you read it with Article 27(8). You cannot constitute a legal parliament, especially post-August 2016, that has more than 2/3 of one gender, yes, and call it constitution. And that's a whole different issue. So there is a basis today. If I wanted to go to court and say, you know what, Parliament passed this law a year ago. Yes. That law is illegal because it was passed by an unconstitutional entity. That wouldn't be a frivolous claim. It's actually a very well-grounded constitutional claim. So even if this Parliament is not going home, yes, because of failing to pass the legislation, which is a constitutional obligation different from constitutional composition of Parliament.
Yes.
then it should go home because it's unconstitutional.
That leaves us in more than a constitutional crisis. It leaves us with a political crisis as well, in that if this parliament has been functioning as an illegal entity, and you know, as I said, you know, passing budget, spending resources, then you know, I'll be grateful for your reflections on, and we'll come to BBI later, but what are the political ramifications and implications of this situation of unconstitutionality and illegality?
The implications could be dire, and this is how. You know, Parliament performs a lot of work. People know Parliament for making laws, but in fact, it's almost impossible for any governmental activity to go ahead without Parliament, and I'll explain. Other than passing laws, Parliament also oversights the executive, and now oversights, to some extent, county governments. Which means, for example, when the president makes a policy or an executive order, legally speaking, that is supposed to be brought to Parliament for scrutiny.
Yes.
And if Parliament was unhappy with it, then that is not a policy that has effect.
Yes.
When it comes to international relations, Parliament does two very critical things that affect us on a day-to-day in terms of international relations. Remember, there is the requirement that any law,
yes,
or any treaty that Kenya now gets into has to go through a treaty making and ratification process.
Correct.
And some of that process sometimes require that whatever instrument that is made is tabled before Parliament and approved before Kenya can sign on it.
Yes.
So even when you think about it from a foreign relations point of view,
yes,
then there is significant concerns. Think about another way, foreign ministers or finance minister. If a finance minister is not approved by Parliament, that person is illegitimate. Yet there is so much a finance minister does in terms of bilateral and multilateral relations, especially when it comes to finances,
yes,
that then if you have an illegal person performing that job, there are questions and implications about whether the agreements, whether the contracts, whether the debt that Kenya is getting into with other bilateral or multilateral actors are legal. So there are so many significant implications.
Yes. Now, so we find ourselves in this political conundrum, that, you know, constitutional and political conundrum. And some of the discussions that, you know, have been taking place here in the political sort of general firmament has been that if the Building Bridges initiative were to be, you know, if it could be added to, that it could be the silver bullet that allows us to punch our way out of this particular problem. And so there are those who feel that this has added some wind to the sails of the BBI boat, that Parliament can sit down and you know, basically orchestrate many of the changes required. But from what you're describing, an illegal Parliament can't actually be able to do that. How would that work? I mean, what I'm trying to ask is, what are the transition mechanisms now? You know, the Supreme Court has said what it has said. The implications are, you've described very, very clearly. How do we, as a political nation, as a society, go about correcting this? The president writes a letter or issues a diktat on the basis of what the Chief Justice has instructed. That means an election, etc., etc. But then there's also discussion of the political side of maybe we can fix this using the Building Bridges initiative.
So first, just at least two reasons why Building Bridges initiative is not a solution. The first one is what we've said. You already have an unconstitutional parliament.
Yes.
How are you going to use unconstitutional parliament to amend the constitution as a starting point? It doesn't make sense. It's not logical. You are giving an illegal entity the power, which is so consequential, because amendment powers are so consequential.
Yes.
To amend the constitution, it's both illegal but undesirable. The second reason is help us resolve the crisis. So how do you resolve the crisis in accordance with the people who are using or who are advocating using BBI? Yes. It's to address the two-thirds gender issue through a constitutional amendment. What does that essentially mean? It means that Parliament has refused to enact the law, an obligation, a constitutional obligation on two-thirds, but it's gonna use a constitutional amendment to get out of that obligation.
Yeah. Okay.
That is ridiculous.
It's an
proposition.
An illegality.
Basically, it means that anytime Parliament doesn't like anything to do with an obligation imposed on it by the Constitution, all it will be doing is to say, okay, we'll just amend this section. Yeah. That is just both ridiculous, but something that Kenyans should not entertain for a minute. But more importantly, I've also heard that there are proposals that the way you deal with it then is you use a constitutional amendment to delete that provision. You can't do that for two reasons. One, this whole illegality, but secondly, inclusion, which is where two-thirds gender rule is located. Inclusion and making sure that we have an undiscriminative society. Those are basic structures of the Constitution. It's what others have argued you cannot amend.
Yes.
Even using a referendum. So there are so many reasons. But thinking about the transitional mechanism, the first one is what is supposed to happen. We are supposed to have a dissolution, and then we are supposed to have elections for members of parliament. All members of parliament, that's both National Assembly and the Senate. There are questions about, are those by elections or are they special elections that give parliament 5 years? My view is that while that is a debatable point, the people who've been arguing that it's a by-election and only gives parliament life that is remaining in this term is the most compelling.
Okay.
Right?
Okay.
And partly when parliament comes back, because it was the punishment for not adhering to the Constitution, at least one of the first business it should embark on is the passage of the two-thirds gender rule law.
Yes.
Even though when you go to Article 261, there seems to be leeway for the new parliament that comes in to be able to stay, it has up to 5 years. Yes. But there is no reasonable basis why a new parliament should be given too much time to pass that law. But there is also the question, how do you even resolve some of the questions that seems not to be addressed by the Constitution? So for example, if you, for people who are arguing that what you get is a new term of parliament, so that we no longer have all our 6 elections at the same date. And so we now have a staggered election calendar. So you have president and county governments on one day, And then 2-3 years later, you have the parliamentary election. Again, we can argue either way, but the best way to resolve some of those questions is to go to the Supreme Court, especially once we have a new parliament, to ask for advisory, because the only entity that has the authority to clarify what the Constitution anticipates whenever there is doubt is the court.
Yeah.
And in a situation like this, because this is not a controversy that pits two groups against each other,
Yes.
it's a controversy that actually the state ought or has an interest in getting resolved. The best court to deal with this is the Supreme Court through an advisory. But an advisory cannot be on a question whether we should be sending Parliament home. The Constitution has already resolved that.
Yes.
An advisory can only be on questions of how do you get out of, or how do you deal with some of the consequences that attends after you send Parliament home.
You know, time flies when we talk. Waikwa. It's one final question, but it's an important one. Is that, you know, there's a bit of sort of almost a philosophical debate underway that that there's something wrong when we judicialize political issues, when matters which should be resolved and dealt with by the political class using the institutions and instruments that are available to them, where, you know, 2/3 gender rule, they're not making it, they need to sit down and sort it out. And we continuously kick this ball. We continue kicking our political footballs into the judiciary, which is not an ideal situation. You're kicking it into a forum that is composed of, you know, individuals who are not elected by Wanyoike, and yet what they decide, that's it. And it also pits, you know, I mean, just the political reality in Kenya has been the executive and the judiciary have been in have had a terrible relationship over the last few years, and especially since 2017, September 1st, when the Supreme Court nullified the election, and we had to repeat it in October 2017. Now, so we got a very poor relationship between the judiciary and the executive, and now you have another arm of government. We have the legislature, which has also been weaponized against the judiciary. If you hear some of the statements that are coming out of the House, and so I wanted to ask two questions. Number one, just your reflections and perspective on you know, the perspective, the idea that we are judicializing our politics, which is a treacherous road to travel, and you know, what are the implications of that going to be? Is the other question that I would ask you, if you reflect from your experience. I had the opportunity to. I've had the opportunity to speak with some of the, you know, experts like Jill Guy, and she mentioned other examples in Canada and India, etc. But, you know, how does one deal with this situation where we run to the courts with our political issues all the time and lock ourselves into a situation where our capacity as a society to be able to resolve our issues through debate, through persuasion, through compromise is removed from our political class and from Kenyans, and therefore can ultimately be seen as undermining the very institutions. They are now at cross purposes or pitting, key governance institutions against each other in a manner that undermines our democracy. Sorry, that's a sort of long-winded couple of questions.
It's the weight of the question.
Yeah. It's a unique
so just a few things on that. The first thing that I really want to underline is how a democratic system should function, and especially a democratic system that is based on separation of power. Disciplined, mature, democratic systems that are based on separation of powers only function through a principle called forbearance. That every institution is willing to have the humbleness to stick to its lane and the grace to climb down whenever it's told it's no longer on its lane.
Okay.
That's the first thing. Unfortunately, for us, and especially for the executive and parliament, but more so for Uhuru Kenyatta, because it's important not to generalize the executive, specifically for Uhuru Kenyatta. He fails to appreciate or understand what forbearance means. Yet he's the first person who should understand that, not for any other reason, because other than being president, he's the head of state.
Yes.
And nobody has bigger obligation of forbearance than the head of state.
Yes.
Because Uhuru is so arrogant,
yes,
and doesn't want to forbear other institutions, then he's collapsed, or he's collapsing democracy. But more critically and without knowing, he's significantly eroded the authority of the head of state,
yes,
and the power and the symbolism that rests with that position.
Yeah.
So we will never have we will never have comprehensive laws that will anticipate and resolve every crisis.
yes,
So forbearance is important, which also allows institutions to sit down and debate whenever there is a crisis, for example, the one we have.
yes,
What happened when the Chief Justice delivered his advisory? MPs started chest thumping, calling him names. Even the head of Parliament or National Assembly, Speaker Justin Muturi, just basically was chest thumping. That is not leadership. What Muturi should have tried to do is to reach out to the president, reach out to Maraga and ask, yes, we've got ourselves into a bad situation. Is there a way we can work out things? Staying within the law, but work out things so that we don't cause more harm. That's the first point I wanted to make about the importance of forbearance.
okay,
And unfortunately, Uhuru has really messed up on that level.
yes,
And obviously given a lot of agency to other individuals like Muturi, who really don't seem to respect institutions. But the second point, now coming specifically to judicialization of politics. Kenyans chose a system we call constitutional democracy.
Yeah.
What that means is that constitution is supreme.
yes,
Politicians are not supreme. The head of state is not above the law. Nothing is above the law, even though for this crisis, we are being reminded, even by people we thought were very progressive and younger members of parliament, we're being reminded that some people believe patriarchy is above the law, because that's the crisis. But we chose a constitutional democracy. One critical element of constitutional democracy is that if you have a crisis or a problem that cannot be resolved amicably and within the law by the institutions that are charged with that responsibility, the ultimate decider is the court.
yes,
And there is nothing at the moment that you cannot bring to court which relates to governance.
yes,
So, and that is how we ended up in this situation. The courts never go around looking for cases. Courts never go around looking for crises. Crises happen, disputes come up, and they are brought to the judges. Then the judges try to work out the best they can. And it's important for Kenyans to understand, we have actually a very disciplined judiciary. A judiciary that tries a lot of the time to step back and leave other institutions to work. And I'll give you one example. When National Assembly and Senate went to court last year on the division of revenue, when they couldn't agree, even though the Supreme Court had powers to decide what should be done right away, what the court did is to ask them to go and negotiate. They could still not agree. They came back and said, we want you to decide for us. Yeah. In fact, in this case, it's the same thing. The Constitution told Parliament, go decide on the formula, go put it in place, and that's all. If they had done that, this matter would never have ended up in court. So the court has no option, and the court has an obligation to resolve the cases that come before it, and to pronounce what the Constitution requires, because the court is the custodian of the Constitution. And just to give you an example, Justice Albie Sachs says, one of the South African foremost judges who served in the first constitutional court soon after South Africa, the apartheid was eliminated. You know, Albie Sachs and a lot of the judges who served in the first constitutional court were activists. Yes. And most of them aligned to an ANC, and most of them very close to Mandela and other ANC leaders. But Albie Sachs gives a story about soon after they were sworn into office, one of the first cases that came to the courts was a case where an order was made that the president, that is Mandela, had to present himself in court. And Mandela, I understand, didn't like it, but he did present himself before a judge as ordered, and did what he was required to do. Because for him, and the story is told that he wanted to show that he actually did that because he believed the Constitution was supreme. Unfortunately, that's not the culture we've cultivated. At least there was a little bit of an attempt with Kibaki. It wasn't always very successful. Kibaki wasn't a saint, as a lot of us would want to say. But with Uhuru, it's just completely gone out of proportion.
Well, that's a fairly grim scenario at the current time. In that, you know, we are already in the crisis, is what I'm hearing from you. As ordinary Kenyans who try to understand this kind of situation. And so I'm looking forward to being able to come back to you, because I expect in the Kenyan tradition, there are going to be multiple cases in court around this matter. So I'll be coming to you for interpretation, not only about the legal aspects and constitutional aspects of it, but also its political implications as the BBI and others roll out as we go into 2022. Waikwa, Wanyoike, thank you so much for your time. As usual, it has run very quickly. Thank you very much for your meeting this evening.
Thank you, John, and thank you for having me.
Thank you.